Doctrine of Harmonious Construction. Dr. Deepak Miglani. This doctrine was brought about to bring harmony between the different lists mentioned in the Schedule 7 of the Constitution of India. Different subjects are mentioned in different lists in this schedule. However, there can be a situation where an entry of one list overlaps with that of another list. This is the time when this doctrine comes into the picture. It was said that the words of the entries should be given wide amplitude, and the courts shall bring harmony between the different entries and lists. Supreme Court applied this doctrine in the case of Tika Ramji versus the state of UP. The term harmonious construction refers to such construction by which harmony or oneness amongst various provisions of an enactment is arrived at. When the words of statutory provision bear more than one meaning and there is a doubt as to which meaning should prevail, their interpretation should be in a way that each has a separate effect and neither is redundant or nullified. The doctrine of harmonious construction originated through interpretations given by courts in a number of cases. The evolution of the doctrine can be traced back to the very first amendment made in the Constitution of India with the landmark judgment of Shankari Prasad versus Union of India. In the landmark case of CIT versus Hindustan Bulk Carriers, 2003, the Supreme Court laid down 5 principles of rule of harmonious construction. The courts must avoid a head-on clash of seemingly contradicting provisions, and they must construe the contradictory provisions. The provision of one section cannot be used to defeat the provision contained in another unless the court, despite all its efforts, is unable to find a way to reconcile their differences. When it is impossible to completely reconcile the differences in contradictory provisions, the courts must interpret them in such a way so that effect is given to both the provisions as much as possible. Courts must also keep in mind that interpretation that reduces one provision to useless number or death is not harmonious construction. To harmonize is not to destroy any statutory provision or to render it fruitless. In the Kerala Education Bill 1951 case, it was held that in deciding the fundamental rights, the court must consider the directive principle and adopt the principle of harmonious construction. So, 2 possibilities are given effect as much as possible by striking a balance. In East India Hotels Limited versus Union of India, 2001 case, it was held that an act is to be read as a whole, the different provisions have to be harmonized and the effect to be given to all of them. Thank you.